Application also. There is a humble prayer for listing of a criminal petition, which is for quashing. It's not been listed for 3 months.
Okay. Give the mention memo to the court master. Loud, bit loud.
Item number 17, my lord. My lord,
Item number?
17, pray for upgradation, my lord. This matter,
Item number?
item number 17, my lord. My lord, sir, IA for suspension of sentence, my lord, conviction.
No, it will go accordingly. We don't upgrade. This court does not upgrade.
2 occasions listed.
Sorry.
Lordship, I beg to mention item number 7. Lordship,
Yes.
as per the instruction of the client, Lordship, as per the instruction of the client, Lordship, I want to withdraw the petition, Lordship.
Okay, Mr.
A.R. Mondal.
A.R. Mondal, Learning Counsel for the petitioners, has submitted on instruction that the petitioners want to withdraw the criminal petition. PP. Mr. R.R. Kosik, learned additional public prosecutor who is in attendance, submitted that the state has no objection to the state prayer. In view of the above submission made by Mr. Mondal, Learned Counsel for the petitioners, the criminal petition is dismissed on withdrawal.
May I please, my lord? Lordship, I beg to mention an IA for listing, my lord. For suspension of sentence, my lord, which was filed on 6/8/2025.
Give it to the court martial.
Any
Court
demand?
martial.
Obliged.
May I please, my lord? I would like to mention one item for listing, my lord. This is a criminal petition, and for a long time it has not come up.
Okay, give it to the court master.
Deeply obliged, my lord.
May I please, Lordship, I beg to mention for listing one case.
Loud, come. Bit loud.
I beg to mention for listing one criminal revision petition, Lordship.
Okay. For what?
Lordship, admission, Lordship. Admission.
Admission?
Yes.
Okay.
Yes.
Daily list for motion. Item 1.
May I please, your lordship?
Hmm.
Lordship, in this case, lordship, we have filed an additional affidavit to bring on record that the time of the conviction, lordship, since when this petitioner is behind the bars. Lordship, perhaps the additional affidavit has not come up with the record. I humbly pray that after some time this matter will be taken up by way of requisition. I will try.
Item
But
2.
make it fast.
Yes, lordship.
Yes, Mr. Koshik.
My lord,
We have received this report, my lord.
Okay, Miss Dev, we'll put it on Tuesday. We'll pass the order.
Lord.
Put it on Tuesday, pass the order, dispose. In your favor. Right?
Lordship, the last occasion, this honorable court granted passed order releasing the vehicle.
Yes,
That-
I am aware of it.
No, that we have submitted bond also, but thereafter they did not release that.
No, this is different.
This
That
is
was
different. This
vehicle.
is for coal.
That was vehicle.
That was a vehicle. It is for coal.
Huh.
But they did
For
not.
that, if you, that is not released, you have to file interlocutory application, don't mix up with that.
No, I don't want to mix up, just
Ah.
to inform the court that.
You
because
file an interlocutory
they-
application if it is not released despite submission of bond.
Yes,
Make an IA,
yes, Lordship.
then we'll see to it.
It's up to
Ah.
Tuesday, we will see whether
I am
because
Dev.
due to the
Agnes,
police.
M. Dev, learned counsel for the petitioner, and Mr. R. Kosik, learned additional public prosecutor for the respondent number 1, State of Assam. Post of Mr. Kosik, learned additional public prosecutor has has placed a report from the investigating officer of the case in deference to the order dated 28/7/2025. Post of. The said report is kept with the case record by marking it as document X. Post of. Place the case on Tuesday
12/8.
for consideration. We'll dispose of
Alright.
it.
Item 3. May I release that? My lord, in this case, my lord, white impugn order, my lord, my
What is the impugn order?
lord, impugn order, my lord, piece 41, my lord.
Page?
41, my lord, annex 9.
Page 41.
There is two impugn, my lord. One is page 37, whereby, my lord,
41.
yes, my lord.
AP is present to them.
My lord,
What
on
is
the-
AP? Agree person.
My lord,
Okay.
I pray my lord for allow me to examine the evidence of PW1 and allow me to produce my evidence.
Yeah, next it.
On 4/6/2000.
What is the application was by agree person before?
No, my lord, application was submitted by my lord, me, my lord, on 4/6/2025, my lord, that is page
No,
38.
no. The proceeding,
Yes, my lord.
respond number 1 here is the agree person.
Yes, my lord.
And respond number 1 filed a DP case.
Yes, my lord.
Okay, seeking number of reliefs.
My lord.
Then what happened? It has been registered and you submitted written
My
statement.
lord, I have submitted written.
Written statement.
Yes, my lord. Thereafter, my lord.
Thereafter, what happened?
PW, my lord, agree party, my lord, it is her evidence, my lord.
Agree party
Yes,
adduced
Mr.
evidence.
But I could not, my lord, cross the, my lord, evidence of the, my lord, agree party, my lord. Showing my lord, post, my lord. But this has been
Absent
rejected,
stating
my lord.
reasons
I have submitted petition, my lord.
submitted the previous
That is
petition.
38, my lord, I have submitted, my lord, my petition, my lord.
Very
My lord, I am government employee, my lord. Due to some unavailable circumstances, my lord, I could not appear on my lord. 6/5/2025, and hence my lord, the learned trial court, my lord, proceeded ex parte argument against me, my lord.
1 minute. But it is not a single occasion. Come to page 34.
My lord,
6/3/2025.
my lord,
Respondent absent without steps.
yes, my lord.
24/4/2025. Respondents are absent without any step.
My lord, what happened, my lord?
Right, 1 minute. Then 37. Respondent is absent without any step. So considering the absence of the respondent, I deem it fit to proceed this case ex parte against the respondent.
My lord.
So it was preceded by 2 occasions earlier.
My lord, what happened, my lord? On 24/4/2025, my lord, I appeared, my lord, and submitted my hazira, my lord. But which was, my lord, not placed in the record, and that is why, my lord, my lord, the learned trial court, my lord, rejected my prayer, my lord. That is, I have, my lord, stated in my petition, my lord, which was submitted on 4/6/2025, my lord. That is page 38, my lord. Kindly see. Annexure 8. Paragraph 3, my lord.
By that time, the order was passed for ex parte proceeding on 6/5/2025.
My lord. On the,
Is
my
it
lord,
not?
on the next date, my lord.
Yes, on 4/6, your petition was, that petition number was considered.
My lord, what happened, my lord? On 6/5/2025, my lord, when, my lord, this ex parte argument was passed, my lord, on that day, my lord, I was on election duty, my lord. That is why I could not, my lord, appear, and I also unable to, my lord, communicate with my.
But what about previous 2 occasions?
On 24/4.
No, 24/4, you see? 34, page 34, 6/3 absent, 24/4 absent.
24/4.
Then it was 3rd occasion,
My lord,
6/5/2025. It was a 3rd occasion. You were absent without steps.
it is, my lord, on 20.
And on that ground, the court decided to proceed ex parte against you,
Yes,
right? Then 4/6 was the next date.
my lord.
So what did you do on 4/6?
My lord, my plea, my lord,
Senior assistant,
on 24/4, my lord,
remote place.
I was appeared, my lord, and submitted my hazira, my lord. But
Oh, on 4/6 only.
no, my lord, 24/4, my lord. That is 24 April, my lord. Which, my lord, which has been explained in my petition, my lord. But on 6/5/2025.
Now, let us read the page 41 order.
AP is present today. Respondent 1 is also present, and Vike petition 511. Date for vacating ex parte order passed against him showing cause. Third person, perused. As per the aforesaid petition, the reason for absence of RI is that on 24/4/2025, just prior to the shifting of new court building, the respondent side filed hazira, but the same has not reflected in the court's order. And on the next day, that is on 6/5/2025, my lord, on 6/5/2025, my lord, I was on election duty, my lord. And I was also unable to communicate with my youngest counsel, my lord. And that is why, my lord, on that day I was absent, my lord. And on the very next day, my lord, I appeared and submitted this petition, my lord, which was.
But 24/4/2025.
Yes, my lord.
The court has recorded. I have duly gone through the case record, but did not find any hazira of the respondents.
Yes, my lord, that is the reason, my lord. I was on the very
And
day.
prior to that also you were absent.
Yes, my lord. Earlier occasion I was absent.
Hmm.
It's admitted fact, my lord.
Yes.
I am not, my lord, denied, my lord. My lord, since my lord, cross-examination adducing evidence is necessary, my lord. So, my lord, I may be allowed to cross, my lord, and adduce my evidence, my lord. Otherwise, I'll be, my lord, prejudiced.
Yes. What do you say?
My lord, otherwise, going by the dates, my lord, he
His
was
conduct is not good.
not good, my lord.
Any
And-
interim order, interim maintenance order was passed in the proceeding.
My lord, another 125 petition was filed, my lord. In that case, my lord, 10,000 rupees.
You were senior assistant,
My lord, yes, my lord.
right?
Yes, my lord.
You were a rich person. Pay
My lord,
10,000 deposit, 10,000 cost.
And another thing, my lord, this petition which my learned friend has enclosed here,
You just for the sake of duty, office duty, you have skipped the court. You did not even inform your counsel also.
No, my lord, that is, I explained, my lord, that
Your explanation I have read.
I
So
tried, my
you are
lord, to
senior
communicate-
assistant. You don't have any regard to the court proceedings,
Kindly
right? For that
consider-
purpose, you have to pay the cost to the respondent, every person.
my lord, kindly peruse page 38.
Hmm.
Last portion, my lord. Enclosure. That is not
Yes.
there also, here also.
Photocopy of Hajira.
For-
Where is that Hajira?
My lord, that petition is not with me
Huh?
at present, my lord. But
Huh?
my lord, the election duty copies, my lord,
It is also not there
It's
with
not
your
there.
petition
I have
to
subsequently,
justify
I have
for
subsequently,
this court to justify something.
I have subsequently procured, my lord.
No, don't hand over.
Election-
Don't hand over. Don't hand over, which you have decided earlier not to enclose.
Now, why I'm saying this, my lord, because that Hazira, if your lordship see the order, there also the court didn't find me. In the
Court
record,
did not find.
didn't find me.
We have to accept the court's finding.
On
Yes.
that day, my lord, court shifting, my lord, process was
Whatever,
going.
we don't know.
Sorry, my lord, my lord, maybe some there mistake on the part of the, my lord, court assistants, my lord.
Cost, senior assistant, you are busy.
My lord, kindly consider, my lord.
Considering at the payment of cost. And it is not that single occasion. There is absolutely no explanation for your absence on 23/3/2025. Is it not?
My lord, on that day, my lord,
Absolutely no
I
explanation.
was
60, hard, mister. Yes, Neem.
Hussein.
A. Hussein, learned counsel for the petition. When is the next date?
My lord, 12/8, my lord.
12th.
Yes, my lord. That is page 45, my lord.
Page?
45, my
Last
lord.
page.
Last page, my lord.
And Mr. R. Kaushik, learned
Hussein. Oh, sorry.
additional public prosecutor for the respond number 2, State of Assam. So stop. The instant criminal revision petition. under section so and so, likha আছে, read with section so and so, has been preferred. Seeking setting aside of orders dated 6/5 2025. And dated 4/6/2025. Passed by the Court of Learned Judicial Magistrate First Class, Dhubri Trial Court. In the course of the proceedings of C full stop R full stop within bracket D full stop V full stop bracket close case number 1014/2021 full stop. By the order dated 6/5/2025, comma, the trial court finding that the petitioner who is the respondent number 1 in the proceedings of or in CR case number so and so, was absent without steps at the trial court. Considering such absence of the respondent number 1, this petitioner deemed it fit to proceed in the case ex-parte against and decided to proceed, deemed it proceed ex-parte against the respondent number 1, comma, and that's petitioner poster. The petitioner respondent number 1, no, opposed of by order dated 6/5/2025, comma, the trial court posted the case on 4/6/2025 for ex parte argument. Post of the petitioner, that's respondent number 1. Submitted an application on 4/6/2023. Oh, sorry, this is 4/6 or what? 4/6/2025 or?
My lord, it may be 25, my lord, but wrongly 23.
4/6/2025. Petition. Petition number 511/2025. Praying for vacating the ex parte order passed against him on 6/5/2025. Full stop. By after consideration, comma, the trial court by order dated 4/6/2025 dismissed petition number 511/2025. Full stop. Para. Having regard to the issues raised in this criminal revision petition, comma, it is taken up for consideration at the motion stage itself, dispensing which the process of issuing notice to the respondent number 1 herein, who is the aggrieved person in CRDB case number so and so, Full stop. Para. The aggrieved person is the wife of the petitioner and their marriage was solemnized on 15/7/2025. Full stop. The aggrieved person instituted the proceedings of CR case number so and so. A DVA condition. DVA con. Under the Protection of Women from Domestic Violence Act 2005, written by DP Act. Before the court of the Chief Judicial Magistrate, Dhubri, seeking a number of reliefs under the Act. Full stop. On receipt of notice from the trial court of Learned Judicial Magistrate First Class, Dhubri, the petitioner who has been arraigned as respondent number 1, appeared before the trial court and started participating in the proceedings. Closed up in the course of the proceedings, at one point of time in the course of the proceedings, the parties, the petitioner, and the aggrieved person and the respondent number 1 filed a joint petition stating that the disputes between them were settled. You submitted joint petition there?
My lord. It's 25.
By filing petition number 975/2023 on 8/9/2023. Stop. The aggrieved person subsequently the aggrieved person on 24/7/2024 submitted before the trial court that though previously petition number 975/2023 was filed on 8/9/2023, stating that the matter had been settled mutually, but no mutual settlement had taken place and the aggrieved person would continue with the case. Post hoc. In view of such submission made by the aggrieved person, comma, the trial court by order dated 24/7/2024 dismissed the dismissed petition number 975 stroke 2023 and posted the case for evidence from the side of the aggrieved person on 13/9/2024 post of the aggrieved person and thereafter submitted her evidence on affidavit post of para. The next dates. What is this petition number? 3497. The next dates, comma 6/3/2025, comma 24/4/2025, and 6/5/2025 were for cross-examination of the
cross-examination of the PW1, my lord, that is.
PW1, that is the aggrieved person.
Yes.
Post of. On all these occasions, comma, the respondent number 1, that is the petitioner, was found absent before the trial court without taking any steps. Post of. The learned trial court finding such absence on the part of the respondent number 1, that's petitioner, before it, comma, decided to proceed ex-parte against him on 6/5/2025. Post of para. On 4/6/2025, comma, the petitioner, that's respondent number 1, the petitioner submitted petition number 511/2025 for vacating the ex-parte order passed against him on 6/5/2025. Post of. In the petition, comma, the petitioner had inter alia stated that he was working as a senior assistant in the establishment of South Salmara Revenue Circle and which is situated in the south bank of River Brahmaputra. Post of. The place is a remote place and there is no good communication to reach the court, trial court at Dhubri from the working place of the petitioner. Post of. It was further stated that he appeared on 24/4/2025 by submitting Hajira, but the same was not reflected in the court record. Post of. It was further mentioned that on 6/5/2025, comma, the petitioner was busy discharging duties in a panchayat election, and because of his election duty, panchayat election duties, comma, he failed to appear on 6/5/2025. Post of. The trial court, on receipt of petition number so and so, the trial court examined the case record and found and reached a finding that there was no hazira filed on behalf of the petitioner on 24/4/2025. Full stop. The trial court rejected the contention of the petitioner as regards his absence on 6/5/2025 by observing that the respondents engaged counsel could have filed the hazira, could have either filed a petition seeking leave or appeared in person on 6/5/2025. Full stop. Full stop. Para. The subject matter of the proceedings of CRDB case number 1014/2021 is claims made by the aggrieved person against the petitioner. That's response number 1. Full stop. Though it is found from the matters on record that the petitioner was absent without taking any steps on 6/3/2024 and 24/4/2025, 6/3/2025 and 24/4/2025. दो ना लगे, दो क्वेश्चन लिखे, दो ना लगे. Post op. It was on third occasion of his absence on 6/5/2025. The trial court decided to proceed ex-parte against him. Post op. Such repeated absence of the petitioner in the proceedings of CR case number so and so cannot be appreciated. Full stop. However, the proceedings involve rights, determination of the rights, obligations, rights and obligations of the parties in question. Full stop. It is the petitioner. If the application filed by the aggrieved person is to be allowed, the petitioner should also have the opportunity to rebut the contentions raised by the aggrieved person. Full stop. Instead of because of the order dated 6/5/2025, the petitioner is deprived from the opportunity of cross-examining the aggrieved person PW1. This court is of the considered view that one opportunity can be granted to the petitioner for cross-examining the aggrieved person full stop. At the same time, comma, one cannot be oblivious to the situation that on all these occasions, because of repeated failure on the part of the petitioner, the aggrieved person had to wait for the final determination of her claim. Full stop. Therefore, comma, the aggrieved person is to be commensurately compensated. Full stop. In view of the discussion, in view of the above, comma, this court deems it fit and proper, comma, in the interest of justice to set aside the order dated 6/5/2025 and the subsequent order and the subsequent orders whereby the proceedings of DV case number so proceeded against the petitioner ex-parte. Full stop. It is informed that the next date of the case is on 12/5/2025. Full stop. The petitioner is allowed to appear and take part in the further proceedings of DV case number so on and from 12/8/2025 onwards, subject to deposit of a cost of rupees 10,000 on 12/8/2025, post of before the learned trial court on deposit of the amount of rupees 10,000, comma, the trial court shall disburse the same amount to the aggrieved person. The criminal petition stands disposed of in the aforestated terms.
My lord, may I pray, my lord, instead of 10, my lord, 5,000 may be impossible.
15,000.
Item number 4.
You are senior assistant. Senior enough to pay 50,000 also. You have means. Yes.
Maybe Lord. That is the criminal petition for the rejection with Jima in system with Amrup, my lord, page 34, my lord.
Succeeded.
My lord, at the evidence stage.
Huh?
Evidence.
Call for a scan copy of the case record.
My lord.
That will do.
Yes, ma'am.
My lord.
Heard Mr. H. Hali, learned counsel for the petitioner, and Mr. R. Kosik, learned additional public prosecutor for the respondent. State, post of this criminal revision petition is preferred to challenge an order dated 5/7/2025 by the learned session judge Kamrup,
My lord.
Amingaon, would you make a special court in NDPS case number 07
07, my lord.
2025, whereby the special court has rejected a prayer for interim custody of a vehicle within bracket Bolero, comma, which the petitioner claims, post of the petitioner has claimed that he is a registered owner of the said vehicle. Post of the issue notice returnable on so and so.
1st September.
The petitioner shall take as Mr. Kosik. You can represent both.
My lord.
As so and so. Response number one, state of.
My lord, actually,
Okay.
by
response-
name, he has,
Response number one. And issuance of formal notice to response number is dispensed
yes,
with.
sir, he will be-
The scan copies of NDPS case number so and so be called for. And not issuing notice to him.
My lord.
Understand.
Item 5.
Yes, Your Lordship, under section 442 and 438, CRPC for revision of petition of PRC case number 530, 1 of
530,
531 PS case number.
One?
PRC case number.
ERC case number.
Yes,
Hmm.
2020 arising out of charges number 471 of 2016 of the dated 30/11/2016 on
Where is the impugn order? Tell me.
interim page number 37, Lord.
37.
37.
Let us read.
Yes. Accused is absent without step. Peruse the case record and it is seen that the accused had filed a petition through his engaged counsel on 23/11/2021 along with order dated 2/8/2021 in criminal petition number 389 of 2020-21 filed by him before the Honorable Guwahati High Court against the order of cognizance of this court dated 10/6/2020. I have seen order dated 2/8/2021 wherein the Honorable Guwahati High Court has been pleased to call for the scanned copy of CD and statement of witnesses recorded under section 164 of CRPC in this case. However, no interim relief had been granted by Honorable Guwahati High Court in order dated 2/8/2020-21. Accused did not appear after that nor file any order passed by the Honorable Guwahati High Court. We have checked the official website of the Guwahati High Court and no subsequent order is found in the criminal petition. In fact, case record reveals that the accused have never appeared in the court since service of summon and not taken any step showing cause of absence since 23/11/2021. Since there is no order of stay from Honorable Guwahati High Court on the proceeding of the case, and yet the accused has not taken any step after 23/11/2021. Issue non-bailable warrant of arrest against the
So
accused person.
what happened to criminal petition? Why
Lordship, from that,
against the order of cognizance, right?
Yes,
Then what happened to criminal petition?
not listed till that clause. Before this Honorable Court not listed.
So you also did not appear. You also did not appear.
Yes, Lordship.
Go and appear.
Yes, Lordship.
Why should we entertain? This is a correct order.
Yes.
Absolutely correct order.
I will appeal, Lordship.
You go appear. We dismiss this petition.
Only kindly recall the non-bailable warrant.
I cannot recall. Have you read this? I cannot recall. Power is not given to me. Show me. Warrant of arrest. Section 72. Every such warrant shall remain in force until it is cancelled by the court which issued it. Which means
Yes.
that court,
That court.
right?
Yes.
Or until it is executed, taken into custody. Go and make a prayer. So, reasons why you have defied for 4 years, absolutely no reason.
Yes, Lordship, I will appear. On next date and
We don't
48.
find. You neither endeavor to get the criminal petition listed for 4 years. You did not appear before the trial court since 2021.
21.
No question of calling it because reason is quite clear. When the court can issue
Actually, there
warrants,
there was a
when
gap
the
between
court can issue warrants.
petitioner along with engaged counsel, Lordship. Due to loss of mobile handset of
Oh
the
no,
engaged counsel.
4 years it is too much.
Yes.
4 years it is too much. Lack of communication ground is too much. And what kind of charge you are facing? Let us see.
302.
306.
306.
Organization was 306. Lord. Earlier FR was 302.
Abatement or what?
Yes, abatement of suicide. Made it a FR. Lord.
Page 34, man.
This is unbelievable then. I don't know, Venus Notch. Notch was resigned in rented house. Krishnagar was working as a driver. He came to know. What is your explanation?
Explanation is that as far as statement of the statement of the witnesses.
That is not, that is on merit. That is on merit.
Yeah.
Right?
Yes.
Your explanation regarding your absence for 4 years.
Yes.
What is your explanation?
Due to lack of communication, Lord.
I'm good. Then I am dismissing it. Hard mistake. Lack of communication. 1 date, 2 date, I can understand. Mr.
G. Fukon.
Z. Pupon. Learned counsel for the petitioner. Yes, Mr.
No statement to that effect, my lord.
Huh?
No statement to that effect, my lord. That lack of communication, I have not found any.
Yes, I page number 7, Lord.
Sense.
Para
And
number 10.
otherwise, my lord,
Para number 10.
Error number 10.
mobile handset, my lord. And it
Trial
seems-
court is hopefully waiting for stay order from the High Court.
Yes.
So he also did not have a.
And it seems, my lord, the trial court has not passed this order, just routine manner, my lord. Trial
No,
court
no, no,
waited, my lord.
absolutely not.
Yes, my lord.
And a first information report was lost before the officer in charge Dispur police station on 13/2/2009
Yes.
by one Prahlad Nath reporting the death of his brother Avinash Nath, who was working as a driver of the petitioner. Full stop. It was alleged that Avinash Nath fell from the terrace of a 6-storied building and succumbed to the injuries sustained by him on the spot. Full stop. It was alleged that the petitioner was behind the death of the said deceased. Post stop. The said affair was registered as Dispur Police Station case number 168/2009 under section 3. Under section
302.
302, Indian Penal Code. And investigation ensued. Post stop. On completion of investigation, the IO of the case submitted a charge sheet, right, charge sheet number 471/2016 on 30/11/2016, finding sufficient incriminating materials against the petitioner for commission of the offense under section 306, IPC. Close stop. From the materials on record, it has emerged that on submission of the charge sheet, the case has been recorded as police report case within bracket PRC number 531 of 2024, and the case was case has been sent to the Court of Landed Additional Chief Judicial Magistrate Kamrup Metro, Guwahati Trial Court for disposal. Post stop. The trial court took cognizance appeared to have taken cognizance of the offense on by an order dated 20/06/2020 and issued process against the petitioner to secure his appearance in the proceedings of PRC case number 531/2020. First up, the instant criminal petition is preferred. Revision petition is preferred against an order dated 25/6/2025. Post of para. For any reference, the order dated so and so is extracted herein below in its entirety. Page 37 of this. From the contents of the order, it can be noticed that during the period from 23/11/2021 to 25/6/2025, the petitioner did not even appear once before the trial court. Post up. This court in criminal petition number
89.
number is there.
Yes,
389/2021 did not pass any interim order granting exemption to the petitioner from appearing before the learned trial court. Post up. Para. The instant petition in the grounds urged in paragraph 10 of the instant criminal petition, the petitioner has urged the following ground: seeking recall of the non-bailable warrant of arrest issued against him by the order dated 25/6/2025. Para 10 to quote kori dibo. The grounds urged by the petitioner in the instant criminal petition is found spacious, SPACIOUS, post stop, para. It is evident that the petitioner received summons from the trial court after the order taking cognizance after the trial court took cognizance of the offense on so and so date 20/06/2020. Post. It is apposite to refer to the following to the provisions of section 90. Section 72 and section 90 of the BNSS. Post. Para having regard to the above provisions, command this court is of the view that the trial court was fully justified to issue non-bailable warrant of arrest against the petitioner on 25/6/2025 because of repeated failures on the part of the petitioner to appear before it during the period from 23/11/2021 to 25/6/2025. This petition lacks, as this petition lacks merit, the petition is liable to be dismissed. It is accordingly ordered.
Item 6.
Okay. Mr. Quashing, bank guarantee. Okay, we'll put it on Wednesday.
Yes, my lord, but otherwise section 11 section 5 of Cattle Preservation Act, my lord, if I am not wrong. Section 11 subsection 5, my lord.
Of
Assam Cattle Preservation Act, my lord.
Assam?
Cattle Preservation Act.
Which one? Region?
Assam Cattle Preservation Act.
Okay, let us, is there any specific provision?
My lord, that has to be equal amount of the good, my lord.
It is observed that 7 lakh is the, which is equal to the value of the vehicle.
Yes.
That is a provision.
Yes.
We'll put it on Wednesday.
My lord.
Or Thursday. 11?
Subsection 5, my lord.
Because otherwise they are giving bank guarantee seems to be onerous. Some
Yes.
11/5. You have changed the petitioner.
Yes.
My lord.
I filed for this petition.
Section
11
11.
subsection 5.
Subsection 5.
5. If I am not wrong, my lord, I don't have the book right now. Hello?
Oh. Yes, there is
Yes, there is a.
bank guarantee. Why did not you point out?
No, there is a clause that it should be bank guarantee. Provision is there. But this honorable court, I passed the judgment, I considered. Same case, similar matter,
Same.
similar cattle, transporting cattle.
Could be par incurium of also.
Yes.
We have to examine that issue.
Well, actually, there are divergent views in our court.
Could be, no. There are Supreme
Yes,
Court
ma'am.
decisions. if it is a specific clause, because we can only interpret the law, we cannot legislate.
Right.
If it is shall means shall, we have to find out. Presume.
The section is mandatory otherwise.
Could be, could be,
Right.
could be.
Could be.
What are the other equivalent, how it has been interpreted? So,
While going through that judgment, I was also thinking one point, my lord, whether, because suppose a car that which has been seized is a 10-year-old car. That value.
No, Bengali not. What is the Bengali? Okay, we'll deliberate on it because the coordinate bench judgments are here.
My lord.
That is to be seen, but whether it is this order is par incurium to Supreme Court judgment.
My lord.
If it is in ignorance of that,
Yes.
we have to examine. Ek order like horse key order is it? Okay, we'll look into this order. Order it right horse key interpret করেছে এইটা order ইয়াতে mention করলে এটা বেলাগে হবে এই order এটা আছে ইয়াতে এই সাইডে order আছে এই সাইডে order দিবেন okay and Mr. J. Ahmed, learned counsel for the petitioner, and Mr. R. Kosik, learned additional public prosecutor for the respondent state, full stop. This increment petition is preferred against an order dated revision petition, huh? Or order dated 19/6/2025, whereby the Court of Session, while granting interim custody to the petitioner of a or interim custody of a vehicle, seized vehicle, to the petitioner, has imposed a condition that the petitioner should submit a bank guarantee of rupees 7 lakh, which is equal to the value of the vehicle. Full stop. Mr. Kosik Leonard, additional public prosecutor, has submitted that wildlife control on cattle, name what was it? Cattle
Cattle preservation.
The condition so imposed is in conformity with Section 11, within bracket 5 of the Assam Cattle Preservation Act 2021. Full stop. In response, Mr. Ahmed Leonard, counsel for the petitioner, has submitted that in a number of cases, this court has held that the instead of bank guarantee, submission of bond equal to the value of the vehicle is sufficient. Full stop. Matter of required consideration. This is the case Thursday. Today we are running short of time. Order get a light ho.
Item 8. May I have your lordship?
Yes.
Lordship, petitioner herein lordship, he is under accused lordship of GR case number 115/2014 lordship. Pending before the learned.
GR case number. How,
Yes, lordship.
there are two GR cases. Why? Page 21.
Yes, lordship.
Your Rajesh Borua.
Yes, lordship. Rajesh Borua. Lordship.
FIR, what is the FIR?
Dated 23/2/23 lordship.
468, 471.
Yes, lordship.
What is the FIR? This one, page?
Page lordship, kindly see page 10 lordship.
Page 10. Patrolling duty, information, illegal, some narcotic drug has been carrying out to a track number of friends out of the driver signal. But the driver runs ahead and all the court and runs by the driver was boy, but he could the driver trying to represent every time city of your director up there and left recording information from the was by the time. Then try to okay, this is an FIR against whom?
Against lordship, one driver.
But the
Lordship in this.
case has been registered as what?
Registered.
468, 471.
Yes, lordship.
Why?
That's why
Recovery of fancy dial.
Hence, but police registered this case again as lordship 468, 471 lordship. Kindly see page 15. This is the
Then
in this case, lordship, in the FIR.
I don't understood the case. Then search sheet was submitted against whom?
Against lordship, there are many accused lordship.
Many accused,
Including Rajesh Borua lordship, this petitioner.
including Rajesh Borua.
Lordship.
Okay.
Lordship, as per the.
It was submitted when?
Lordship, as per the.
2010.
charge sheet was 10, Lordship.
Okay, we are in 2025. Good,
Lordship.
good.
GR case Lordship started on 2014, but after issuing summons Lordship, he did not receive any summons Lordship. Because he originally from Kerala, instead of a.
Huh? Boro is from Kerala?
From Tripura Lordship, sorry. From Tripura.
Tripura.
He belongs to Tripura Lordship. Initially, he did not receive any summons, but later on, his family member received the summons, but he came to know that Lordship, the last time put on 23/2/23 Lordship.
Huh? Please tell me properly.
Lordship, initially, he did not receive any summons issued by the landed tribunal Lordship, but later on, his family member received summons. But in the last part of 2024 Lordship, he came to know that the landed trial court issues PNA and NBW against him by order that.
Any receipt of summon order somewhere?
Lordship, there is have not annexed, Lordship, could not annex. Lordship, kindly see page 21, there's this is the order whereby the issued NBW and PNA Lordship.
Mr. Goswami,
Lordship,
initial order is at page 21.
Lordship,
Lordship,
page
need to appear, Lordship, and fetch the.
Right. Initial order is at page 21.
21, my lord.
Tell me what is correct, what is wrong there.
It is stated that not traceability.
Hmm?
Someone issued to co-accused persons.
I deem it
Right.
justified
Yes,
to issue PNA
yes, my lord.
along with NBWA.
Yes.
Sustainable.
Perhaps, my lord.
Lordship, just maybe.
Right.
Okay. Oh,
Yes,
Tuesday.
my lord.
Not sustainable.
Lords. And also, my lord, regarding the FIR, my lord, that is interesting, my lord.
That is interesting, but we could not, we cannot do anything.
Lordship.
Mr.
Yes, Islam Lordship.
Okay, yes, Islam, MP Goswami, based on Tuesday.
Lordship.
We'll pass the order.
NBW.
Item 9.
May it please.
This criminal petition is against assailing an FIR, charge sheet, and the order taking cognizance of it.
FIR,
Charge sheet and order taking cognizance by the learned minister below.
so basically whole proceedings.
Whole proceeding.
Which
Yeah.
one?
The first one.
No, means what is the proceeding?
Proceeding is the
Order taking, let us go to the order taking cognizance.
that is at page 51, Lordship.
Yes, PRC 236.
233.
Submitted charge sheet against 296B.
296B.
351. Let us just understand what is 296B.
296 Obscene Act and Song. And
Obscene,
yes,
290
Obscene song, right.
এখন ক'ত গ'ল বা? ইয়াতে আছে নেকি? BNS নেকি এখন আছে যে? Okay, 296.
296 2.
296
B.
296B. Obscene acts and songs.
Yes.
Sings, recites, utters any obscene song. Banners and words, near any public place. Okay. Time 3 months. Okay. Next is 132.
Next is 132 assault or criminal force to deter public servant from discharge of his duty.
132.
Two.
Okay. And then what is 351?
This criminal intimidation. Your Lordship, background fact is that
1 minute, 354, there are many brackets. Okay,
your background fact.
where is the FIR?
FL, before coming to the FL, I'm coming to background facts also. In pursuant to a NIT issued by the NF Railway for hiring of vehicle, the petitioner was awarded a contract wherein he has provided 2 vehicles to the NF Railway Authority, one at Tinsukia, one at Morian. So far the vehicle posted at the Tinsukia station, one inspector, that is the respondent number 2, Pawan Kumar, at the very inception, he started to demand a bribe for maintaining the proper logbook. So as the petitioner refused to give the bribe, so he started to disturb in different ways. He started to absent the vehicle in sometimes. In such a situation, petitioner lodged a complaint before the Divisional Security Commissioner, NF Railway, that is a annexure 1, page 22, against that inspector. So he is demanding bribe, he is illegal things. So after this complaint, as nothing has been done by the railway authority and he is continuously disturbing, the petitioner lodged another complaint on annexure 2, page 26 on 6/12/2024. On the basis of these complaints, the railway authority initiated a departmental inquiry against this inspector. And he, having come to know about this inquiry, on 5/1 called the petitioner to the RPF post. And the petitioner, along with his 2 friends, visited the RPF post, wherein this inspector demanded to withdraw the complaint lodged against him. But the petitioner refused. After refusal, at 9 p.m., he lodged the FIR at page 29.
Before GRP.
Before the GRP.
He is from RPF.
He is from RPF, inspector, TSK RPF. This FIR was lodged before the GRP. This is, I am praying for.
Okay.
Then
Search sheet submitted.
Search sheet submitted.
When?
In the search sheet, interesting, very interesting, Your Honor.
On when?
Search sheet submitted on 31/3/2025.
Okay.
Page 30.
Page 30.
Here another fact. Okay. This first FIR was logged at 9 p.m. before the GRP. This inspector, through his junior officer, lodged another FIR before him. And he registered a case, another case, that is at page 52.
Page?
52.
Okay.
Here IPF.
Same FIR.
Same incident. Same alleged.
And what, that was also succeeded.
That was also succeeded, prosecution report filed and a cognizance taken. That was, we have challenged, that was stayed.
Okay, hard Mr. Asdekar. Counsel for the petition. Yes, Mr.
Yes, my lord. Who are for the same.
Some afterthought counterblast.
Yes.
With malafide intention.
And FIR also I seen, my lord.
Malafide.
FIR also, my lord. Same facts, my lord.
And previous complaint was there against him.
Yeah.
And see the page 52.
No, see, 52 is the one.
See, his name was already the same, exactly same.
Yes. Exactly.
Same FIR.
No.
Another he lost before the GRP, another through his junior representative.
Mr. Asdekar, learned counsel for the petition, and Mr. MP Goswami, learned additional public prosecutor for the respondents. Number 1, State of Assam, post of the instant criminal petition under section 528 BNSS is preferred seeking quashing, setting aside and quashing of the criminal proceedings pertaining to P post of R post of C post of like a police report case within bracket PRC number 236/2025 presently pending before the Court of London Judicial Magistrate First Class at Tinsukia Trial Court. The petition has also sought quashing of the setting aside and quashing of the FIR lodged registered as
GRP,
TSK
GRPS case number 1 of 2025.
And a consequence receipt submitted in that connection, post of issue notice returnable in 4 weeks. As Mr. Goswami has appeared and accepted notice on behalf of the respondent number 1, State of Assam, issuance of formal notice to respondent number 1 is dispensed with. The petitioner shall take steps for service of notice upon the respondent number 2 by registered post with AD as well as by usual process within 3 working days from today. Post of. Para. From the FIRs, 2 FIRs lodged in connection with Tinsukia GRPS case number 1/2025, dated 5/1/2025, and
RPF post TSK case number
RPF
post TSK
TSK case number 02/2025, dated 5/1/2025, comma. It is primarily evident that with the same set of allegations, comma, 2 side 2 affairs were lodged, full stop. After investigation, comma, search sheets were submitted in both the cases, full stop. The proceedings pursuant to a TSK so-and-so case number presently pending before the Court of Land Special Judicial Magistrate within bracket Railway First Class, Tinsukia, in the form of SRCR case number 1149/2025 has already been stayed by an order dated 20/06/2025, passed in criminal petition number 681/2025. First of, it is contended that prior to the affairs, comma, the petitioner herein had brought the activities of the respondent number 2, that's informant in bottom case 2. We now to TSK or
case 22.
Tinsukia GRPS case number. On 3/12/2012 and 5/6/12/2024. 3/12/2024 and 6/12/2024. And the FIR was clearly a counterblast to those complaints and was with malaparte intention. Having regard to the above projections, comma, it is observed that observed in the ordered in the interim that further proceedings of so-and-so case number presently pending PSC number 236/2025, presently pending before the Court of Land Judicial Magistrate First Class Tinsukia shall remain suspended till the returnable date.
Station came in search of him, my lord. Then he came to know that, my lord, in connection with a GR case, my lord, NBWA has been issued against him, my lord. And now he is willing to appear before the court, my lord. And if your lordship produces the entire first order sheet I have produced before your lordship, it's a huge one, my lord. There are several orders, but relevant orders your lordship will find at page 30, my lord, Annexure 5, by which NBWA was issued against the petitioner, my lord. And then, my lord, when it was not executed, then if your lordship come to page 32, my lord, that is relevant, my lord. Now, it was directed.
You were arrested earlier?
Yes, my lord.
You were arrested earlier?
My lord, he has been arrested, and subsequently search sheet was found there.
And you were granted bail?
Yes, my lord.
Okay.
During the investigation, he was arrested, my lord. And at that point of time, he was residing in Guwahati. Now he is from Nagaon. He is residing there, my lord. And that's why, my lord, page 32, my lord, the concern OC was directed to personally appear before the court, my lord, because the concern OC had not executed the NBWA issued against the petitioner. So prior to NBWA, if a summon or nothing he has received, my lord. So now he is willing to appear and cooperate with the trial, my lord.
When the charge sheet was submitted,
Charge sheet was submitted on, my lord, page 24, my lord. It was submitted on 22/5/2017, 19/6/2017, my lord. Charge sheet dated 19/6/2017, my lord.
you are Mr. Raju Bora.
Raju Bora, my lord.
Oh, see that it was an
Page 33 is the latest one. Already.
Is 30?
33.
4/4/2025.
Lordship. Thereafter one order, manner, but this is relevant.
Hmm? When NBW was issued first?
My lord, page, it was issued
31.
on 22/11/2018, my lord.
Huh?
No, no.
NBWA
4 to
4/2019, my
4
lord.
to 19. Page
Page
30.
31.
Okay. Yes. Other two persons are regularly appearing.
No.
Yes, my lord. He will also appear.
When is the next date?
Next date in 19/5, my lord.
15/9.
15/9, my lord. Page
You
32,
appear
my lord.
within 15 days.
Page 32.
15 days. Heard Mr. DP Bora. Planet. Counsel for the petitioner. And Mr. MP Goswami, Learned Additional Public Prosecutor for the respondent state. Full stop. The in a first information report lodged on 22/5/2017 before the officer in charge, Gorsuk Police Station, by one Dilip Kolita, acquisitions were made that allegations were made that the informant's friend, one Dipen Kolita, was seriously injured by a number of persons and snatch away valuables from them. Full stop. The said affair was registered as Gorsuk Police Station case number 200/2017 under sections 341, 325, 384/34, Indian Penal Code. Full stop. In the course of investigation, the petitioner and two other accused persons, namely Joydeep Das and Jalil Ali, were arrested and they were forwarded to the Court of Chief Judicial Magistrate, Kamrup Metro at Guwahati on 26/5/2017. Full stop. Subsequently, all the three accused persons, including the petitioner, were allowed to go on bail for rupees 10,000, each with one local security of the like amount, by an order dated 22/6/2017. Full stop. Bail bonds and affidavits were thereafter submitted on 29/6/2017. And the same were accepted. Post of upon completion of investigation, the charge sheet in connection with Gorsuk Police Station case number was submitted by the IO on
19/6/2017, my lord.
on 19/6/2017 by charge sheet number 1991/2017. Post of para. After submission of charge sheet, the proceedings of GR case number 66778/2017. Corresponding to Gorsuk Police Station case number so and so was started before the Court of Learned Judicial Magistrate, First Class Kamrup Metro, Guwahati, Trial Court, Post of. On receipt of summons, the other two accused persons appeared before the trial court. Post of. Insofar as the process summons issued against the petitioner there was report that after issuance of summons, bailable warrant of arrest was issued against the petitioner. Post of. A report was placed on 4/2/2019 to the effect that BWA issued against the petitioner had returned with a report that the petitioner could not be traced at the given address. Post of. On the basis of the said report, the trial court had ordered issuance of non-bailable warrant of arrest against the petitioner. Post of. By subsequent orders, the trial court issued a warrants of NBWS against the petitioner. Post of. When the case was posted on 4/4/2025, the trial court directed the officer in charge Nagaon Police Station to appear in person before the court to show cause as to why necessary action shall not be taken against him for non-execution of the NBWS issued against the petitioner. So the court also ordered the issuance of fresh NBW against the petitioner. Post of. Para, it is stated above that the next date of the case is fixed on 15/9/2025. Post of. Para. The petitioner has projected that the summons issued by the trial court was never received by him. Post of. It is submitted by the petitioner that the occurrence of the incident was at Guwahati, and subsequently the petitioner shifted his base residence to Nagaon. Post of.
Actually, he is originally from Nagaon. In the search sheet, his original address is mentioned.
To his original residence at Nagaon. Post of. But at the Nagaon residence also, no, the available BWS as well as the NBWS were never executed. Post of. Notwithstanding the same count, the petitioner has submitted that he is ready and willing to participate in the proceedings of GR case number so and so before by submitting himself to the jurisdiction of the trial court henceforth, and there will be no default on his part, no default in appearance on his part, henceforth, full stop. Para. The FR was lodged in the year 2017. Full stop. And the charge sheet was submitted also in the year 2017. Full stop. Since the proceedings of the case number so and so is pending, before the trial court since then, wherein the other two charge-sheeted accused persons are appearing. Full stop. It is due to non-appearance of the petitioner, the proceedings of the case number has not proceeded further. Full stop. Having regard to the projections made and it is in the interest of all the stakeholders, including the prosecution, the witnesses, and the accused persons, an expeditious conclusion of the proceedings of ZR case number so and so is necessary. Full stop. Having regard to the projections made by the petitioner regarding non-service of summons and stroke or non-execution of the warrants of arrest, and the undertaking given by the petitioner that he would submit to the jurisdiction of the trial court by appearing in person within a stipulated period of time, provided the NBWS issued against him be kept in abeyance within such period. This court is of the considered view that for the interest of justice, more particularly, in the interest of an expeditious conclusion of the proceedings of so and so, the NBWS issued against the petitioner can be kept in abeyance to allow the petitioner to appear before the trial court within a period of 15 days from today. So it is accordingly ordered. In view of the undertaking made by the petitioner, it is observed that the petitioner shall appear before the trial court within a period of 15 days. Full stop. If the petitioner submits an application seeking bail before the trial court, upon such appearance, the trial court shall consider such application on its own merits and in accordance with law. With the above observations and directions, the instant criminal petition is disposed of. No cost.
Item 11.
Please, Your Lordship. Criminal petition challenging the order issuing non-bailable warrant of arrest.
How many times?
How many times, Your Lordship? Initially issued on 26 March 2025. Thereafter, report not received. What happened, my lord, in this
26.
case?
3.
Kindly see page 30 also.
Page
30. You were
30.
Initially, I have appeared, my lord. After obtaining the copy of the charge sheet and all, I have challenged the proceeding as well as the charge sheet before this honorable High Court.
304A.
That's it.
Okay. Heard Mr. P. Sharma, Learned Counsel for the petitioner, MP Goswami, Learned Additional Public Prosecutor for the respondent state. Full stop. And FI was a first information report was lodged before the officer in charge Gaurihagar Police Station, Shivsagar on 13/12/2021, seeking investigation in connection with death of one Biswajit Borua, post op. In the FIR, the informant stated that on 13/12/2021, Biswajit Borua, along with one Sanjay Das, was proceeding in a two-wheeler, and the two-wheeler was knocked by a four-wheeler vehicle bearing registration number AS01/DY-2727. Post op. As a result, Biswajit Borua sustained injuries and succumbed to the injuries. Post op. The driver of the four-wheeler, along with two passengers, were detained. Post op. On the basis of a said FIR, Gaurihagar Police Station case number 174/2021 was registered under sections 279, 337, 304A, 427. Post op. Upon completion of investigation, a charge sheet under section 173(2) CRPC was submitted by the IO-wide charge sheet number 25/2022 on 30/04/2022, wherein the petitioner had been charge sheeted for the offenses under section 279,
279, 337,
304A,
304A.
227 IPC. Post op. Para. The proceedings, on submission of the charge sheet, the case has been registered as police report case PRC number 1135/2022. And the case proceeded before the Court of Learned Judicial Magistrate First Class Shivasagar Trial Court. Full stop. You are Biswajit Mohanto?
Yes.
On receipt of process from the trial court, the petitioner appeared before the trial court on 17/10/2023 and submitted an application for recalling the bailable warrant of arrest issued against him. Post op. The said application was allowed and the petitioner was allowed to go on bail of ₹10,000 with suitable surety. Post op. Para, when the case, what matter is pending?
Yes, my lord.
What did you do?
We have challenged it after receiving all this charge sheet and copy. That is criminal petition 142/2023, and that was duly informed to the learned trial court. But due to some miscommunication, thereafter bailable warrant of arrest was issued. On in that party connected case.
Challenging. The proceeding is against him. The petitioner prepared a petition, criminal petition.
Criminal petition.
Any number?
142/2023.
Before this court.
And the informant did not appear after this.
However, no order of stay
No order
was passed by this court post of when the case was posted before the trial court on 10/7/2024, the petitioner was absent with steps stating that the case was pending, criminal petition was pending before this court for admission hearing. Post of. But the trial court rejected the petition, finding it unsatisfactory due to absence of any supporting document, and proceeded to issue bailable warrant of arrest against the petitioner. Post of. On the subsequent dates, 12/8/2024, bailable warrant BWA was, subsequent date, 26/3/2025. The petitioner was found absent without steps, and a report was placed before the trial court that the BWA issued against the petitioner had returned with a report that petitioner was not found in the given address. Post of. The trial court had thereafter had issued NBWA against the petitioner, posting the case on 9/5/2025. Post of. No report was placed as regards execution of the NBWS on the subsequent date before the trial court. On the subsequent dates, 9/5/2025,
10/6/2025,
10/6/2000,
and 19/7/2025.
10/6/2025 and 19/7/2025.
Lordship, I want to appear now.
Post of. In the above backdrop, the petitioner has approached this court by the instant petition, criminal petition, submitting that the petitioner is ready and willing to participate in the further proceedings of so-and-so case number, PRC number so-and-so before the trial court. Post of. The petitioner submitted that in view of the apprehension that he might be taken into custody in execution of the NBWS issued against him by various orders of the trial court, the petitioner is not in view of knowledge, has stated that there is an apprehension that in the meantime he might be taken into custody in execution of the NBWS issued against him by the trial court by previous orders. Post of. An expeditious conclusion of the proceedings of PRC number is to the benefit of all stakeholders, prosecution, witnesses, and the accused. Post of. As the petitioner has undertaken that he is ready and willing to participate in the further proceedings of PRC number so-and-so, and there will not be any default in his appearance on the dates of the trial. This court is of the considered view that the NBWS issued against the petitioner can be kept in abeyance for a period of 15 days from today, so as to enable the petitioner to submit to the jurisdiction of the trial court by appearing in person within that period. So it is accordingly ordered, if the petitioner appears before the trial court within a period of 15 days from today and submits an application seeking his release on bail, the trial court shall consider the application on its own merits and in accordance with law. First of, with the above observation, the criminal petition stands disposal.
Item 12.
May please allow, sir. But we have challenged an order, my lord, pending charges. Sir, Lordship-
Charges.
Charges. Mr.
Charges.
Lordship will kindly see the FIR, my lord, at page number 28. 28 is the FIR.
When is the next date?
Next date is fixed on Monday, my lord.
Monday.
Yes. That is the problem.
Problem for this court also.
Yes. May I read the FIR, my lord? Otherwise, my lord, what happened was that, my lord, once cognizance was taken, my lord, and copies were delivered, we filed a petition seeking discharge. That petition, my lord, was filed on 17/5/2025. The Lordship will kindly see the orders. (17/5), my lord, we filed this petition, my lord. That petition, my lord, has been annexed at page number 72. There, my lord, the court fixed 11/6/2025 for necessary order. On 11/6/2025, a different Zimma order was passed. And if your Lordship will see the next page, it was fixed on 8/7/2025 for order on petition number 485. That is the discharge petition. Whereas, my lord, on this date, my lord, on 8/7/2025, your Lordship will see page number 80. Without even disposing the said petition, my lord, the learned court below straight away frame charges. That is page number 80. Nowhere there is any mention about that said petition, my lord. Whether it was allowed, whether it was rejected, my lord, we do not know. Simply, it has been said that hard, peruse the record and all other
We'll
relevant.
make an application on Monday. We'll take it up on Tuesday or Thursday.
My lord.
Right?
Yes.
You make an application
My lord.
taking adjournment before a trial court.
My lord.
On Monday, we'll take it up on Tuesday or Wednesday, next week, any date.
My lord. If a liberty is given, my lord, take adjournment, my lord, from the delay.
We'll observe that heard Mr. Asdas, learned counsel for the petitioners, and Mr. MP Goswami, learned additional public prosecutor for the respondent state post of the petitioner. Repose this court by the instant criminal petition against an order dated 8/7/2025, whereby charges under sections 198, 316 within bracket 5, stroke 3 within bracket 5 of the Bharatiya Nagorik Bharatiya Nyaya Honita 2023 been framed against them. Post of it is the contention of the petitioner that seeking discharge, the petitioners prepared a petition which was registered and numbered as
485.
485.
Plus 25/26.
20?
25/26.
25/26. But the order dated 8/7/2025 is silent as regards the outcome of petition number so-and-so. The matter request consideration, first of all, as due to paucity time, this petition could not be taken up today. First of leaves the case on Monday, not Monday, this August 13, on 13.
Yes.
And the petitioners are at liberty to make, inform the trial court as regards pendency of the instant criminal petition for consideration on so-and-so.
Any of us.
The handling method, item number 1.
Good.
May I please your lordship. Lordship, the factual background of this case is this, lordship, that on 19/2/2024, by order dated.
You earlier something happened, no? There was elevation. You always,
Lordship,
I used to give preference and you always come nick of time.
Lordship. By way of an additional affidavit, lordship, I have brought on record the date since which this petitioner is behind the bar, lordship.
Mr. Mehdi, Monday.
Monday,
Actually, I am running short of time.
lordship.
PP Mehdi, MP Goswami, Tuesday. Release the case on Tuesday.
One, we are not party.
Huh? You are not party?
No.
Okay. I'll release the case on Tuesday.
Obliged, lordship.
For admission, item 13.
Yeah, please, Lordship. If this
What is the
petition
offense?
is against conviction,
Criminal appeal, huh?
No.
415. Mr.
M. Pathak.
M. Pathak. Page 14. Two petitioners, huh? Accused appellants. Judgment in order 11/7/2025. Special Judge Bongaigaon, Special Court. Special within bracket NAR case number 02 within bracket BGN 2024. Conviction under section
20B.
20B Roman 2 within bracket capital C. Read with section 29 NDPS Act. Rigorous imprisonment for 10 years each and to pay a fine of rupees 1 lakh each in default of payment of fine. Simple imprisonment for another 6 months each. I've gone through the grounds urged in the memorandum of appeal. Criminal appeal is admitted for hearing. Case records of NDPS so. Call for issue notice, returnable 4 weeks as Mr. Goswami has appeared accepted. Issuance of formal notice, dispense to it. This is the case of the 4 weeks.
14. May I please ask? This is a appeal against conviction, the MP note at page 28.
Page 28.
The relevant portion your lordship will find at 107 page, where he has been convicted for 8 years under section 304 part 2 IPC.
Oh, you are the only one. Others have already approached.
This is the other.
Others have been given only 3 months.
3 months.
You are 10. We have to
For 8 years, sir. And
8 or 8.
8 years.
So I would be after.
Lordship, I need to submit in regards to the IA, as because interestingly in this case, your lordship, there is a cross case where the informant as well as the PW, almost all the PWs, PW 1, 3, 4, 5, 6, 7, 8, 10, 13, all are being convicted, including the informant. And lordship, in that case, he has been made he has been regarded as a victim. And he has been also given
Yes,
compensation.
Mr. Counsel, I would have considered it, and you have to wait for next week then.
Yes.
For consideration, not today.
It is below 10 years, so lordship, your lordship can kindly consider the IA.
No, I am saying that today I am running short of time to consider your submissions. On any day in the next week.
Yes, Lord.
Right? We keep it as a whole because we'll not admit the appeal. We'll consider I at the same time if you find that he has a case made out.
Yes.
Okay, Mr.
S. Ahmed.
S. Ahmed.
If your lordship may
Appellant.
kindly fix the
Appellant.
matter on 20, your lordship. I will be-
Appellant and Mr. MP Goswami, additional public prosecutors, a small state. This is the case on Thursday.
Lordship on 20, your lordship, I will be out of station. 20 of.
Oh, till 20.
You want on 20,
I
madam.
am 20 of
We're
August.
putting it on 14
I am not, I will be not available, your lordship. I will be out.
when
of
you
station.
are available.
I will come on 19, your lordship.
19. Okay, then 20 or 22 kumara, right? 20 तारीख, 20 तारीख.
20.
Item 15 for orders. Under this petitioner in jail.
Yes.
Yeah.
This is for what? Already admitted.
Today, my lord, for my lord.
Aye.
I'm for.
Yes. Yes, tell me.
My lord, 2 years,
What is the conviction period?
10 years, my lord, under section 326.
326.
My lord is jail, my lord, 2 year and 2.5 year.
Huh?
2.5 year.
Already?
Yes.
Already in custody?
Yes.
2.5
Already in jail, 2.5 year.
Since when is the date of judgment? Okay.
Date of judgment 21/3/2023.
Okay. Any glaring discrepancy? Any glaring
Section 326 may not attract, my lord. Maybe a case of 324 or 325. My lord, a cut injury in 2 fingers, ring
Oh.
finger and little finger.
separated?
No, not separated. Not separated.
No, where is the medical report?
Yes, my lord. Kindly see, my lord, running page 34, detail of injury, part of judgment. Running page 34, the part of judgment, man. Detail of injury.
Compound fracture. So fracture includes
320.
320. Comes within the section 320 perhaps or
320.
which describes grievous hurt.
Subsection, my lord.
My lord, anyway, my lord, I pray for bail, my lord.
Right. You have every right to seek bail, definitely.
Prior to my lord conviction, he was in jail for 40 days.
One.
He was first arrested on 15/7/2020 and released on 24 August 2020.
How many petitioners?
One petitioner.
What is his name?
My lord, Dildar.
Dildar.
Dildar. Actually,
Okay.
2 persons convicted. Another petition filed, my lord, for criminal division. 3 years, 3 month punishment.
Okay.
His father.
Where is the sentence part?
My lord, is page 46, my lord, paragraph 55.
Dildar is 10 years.
10 years. Father, my lord, 3 years.
Was
convicted,
sentenced
3 years.
to pay a fine.
And this is his son, my lord.
Mr. Goswami, there appears to be some discrepancy
My lord,
regarding the nature of the event.
actually, my lord, the father of the
Some discrepancy in the nature of the testimony. How he sustained the injury.
Yes, but the thing is that, my lord, the victim, the factum that he got injured in the hand by the blow given by this person is there, my lord.
Okay, 2.5 years.
my lord,
But Mr. S. Sohan,
taken.
S. Sohan, learned counsel for the applicant appellant. And Mr. R. Kosik, learned additional public prosecutor for the respondent state. Post up. The applicant, as the appellant, has preferred the accompanying criminal appeal against a judgment and order dated 21/3/2023 passed by the Court of Learned Assistant Sessions Judge Udalguri in Sessions case number 40 of 2021. Post up. The criminal appeal has already been admitted for hearing. Post up by the judgment and order dated 21/3/2023. The appellant has been convicted for the offenses under section 326 and section 447 of the Indian Penal Code, IPC. For the offense under section 326, IPC, the appellant has been sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of rupees 10,000, in default of payment of fine, to undergo simple imprisonment for another 6 months. For the offense under section 447, the appellant has been sentenced to undergo simple imprisonment for 3 months and to pay a fine of rupees 5,000 in default of payment of fine, to undergo simple imprisonment for another month, full stop. The sentences are ordered to run concurrently, full stop. It is submitted by the learned counsel for the applicant appellant that since the date of the judgment and order, since the judgment and order dated 21/3/2023 of conviction and sentence, the petitioner, appellant is undergoing the term of sentence, and as on that, he has spent more than,
My lord, prior to my lord conviction.
more than
My lord, 2 year, 6 months.
2 years, 6 months, including the period of custody.
Yes.
During the period of investigation. First of para 389 to the fixed term of Supreme Court additional. He has further submitted that there is a discrepancy in the testimony of the two main witnesses, PW1 and PW2. Post of para. Así que has been sound. Itu mohon kepada itu ya sendiri. Menurut asli kepada. When a person in Bhagwan Ram Sinde versus and another versus State of Gujarat. The Honorable Supreme Court in so and so. Bhagwan Das Rana Sinde Gosai versus State of Gujarat. 1999 4 SCC 421. Honorable Supreme Court has held when a convicted person is sentenced to a fixed period of sentence and when he files an appeal under any statutory right, suspension of sentence can be considered by the appellate court liberally unless there are exceptional circumstances. Post para. Having regard to the discrepancies in the testimony of PW1 and PW2 and the period of sentence already undergone, I am of the considered view that the applicant appellant has made out a privacy case for suspension of the sentence pending disposal of the appeal, which has already been admitted for hearing. The instant application is preferred by the appellant for suspension of execution of the sentence passed against him and for his release on bail. It is therefore ordered that pending disposal of the appeal, the execution of the sentence passed against the appellant shall remain suspended, and the appellant is allowed to be released on bail subject to deposit of a bail bond of rupees 10,000 with one local security like amount to the satisfaction of the trial court.
One small bill. Under 447, my lord, fine is 500, not 5,000.
Silo,
Item 16.
May it please your lordship. Hearing the petitioner was convicted under section 10 of the.
How much
POCSO Act.
period?
5 years, my lord.
Under offense?
Section 10 of the POCSO Act. But my primary ground here in this appeal is that, my lord, he was a juvenile at the time of the alleged offense. He was a juvenile at the time of the alleged offense.
Did you raise it?
No, my lord, it was not raised at the
not
time of
raised,
the trial.
Not raised, not considered by the trial court. How can you say?
My
Unless you raise this plea before this court.
We have raised it before this court. No?
This court?
Yes, yes.
Okay.
I have annexed the documents, my lord. If lordship takes up the criminal appeal, Annexure 5, page 93 is the school certificate.
Yes, regarding suspension of sentence in a POCSO case, whether notice is to be.
They are appearing.
You have appeared. Okay, we'll put it for consideration then. When is it?
Should I direct an inquiry by the Juvenile Justice Court? I'm not praying for bail also.
You are not.
I'm saying at this stage, lordship may direct the Juvenile.
This
Justice
IA is for juvenile or
No,
what?
my lord. It is bail and suspension of sentence, but the contention is that he was a juvenile, both in the criminal appeal and the IA.
Okay, okay. Okay. But today will be difficult, sir.
Friday
We put it on Friday
On the-
as day for the appellant and Mr. R. Kosik.
Correct.
Respondent number 1, State of Assam. Mr. D. Gogoi, Learned Counsel has submitted that he has entered appearance on behalf of the respondent number 2. Post of as regards the issue, as an issue has been raised, the Learned Counsel for the parties has submitted that the case be listed on another date, list the case on Friday. Oh, then Thursday. Thursday or Monday? Monday will be. Thursday will be the hearing fixed place. Will consider your juvenile plea. 18.
18-8. Item 17.
Yes, Mr. Alom.
My lord, here in this case, my lord, I am paying for bail of the petitioner is
How much?
on previous bail of the court, my lord.
Not previous bail, face bail.
Page 33, your lordship.
Period.
Period 2 years, my lord. With fine
Can
of
be
the-
done, Mr. Kosik. Can be done.
Done.
Under what section?
Only 354, my lord.
354.
My lord.
POCSO is gone, I think.
Page 33, your lordship.
POCSO gun, my lord.
Notice served,
Notice already issued, my lord, and we have.
furnished.
Since POCSO has gone, my lord, I think that is not
354.
354.
So 2 years.
My
Heard Mr. I Alom. Learn it. Issue notice. Why issue notice? Is a statutory appeal? Okay, heard Mr. I Alom. Learn it. Counsel for the accused appellant. And Mr. R. Kosik, learned additional public prosecutor for the respondent number 1 state. Post up. Any service?
Service, my lord, we have already
Mr.
taken
Mr.
steps for respondent number 2, my lord.
lordship here, actually case was registered under POCSO, but conviction was under 354. So my lord, perhaps it will not require.
As the conviction of the accused appellant is not under any offense, not under any offense of the POCSO Act, and is under section 354 IPC. Service of notice, it is submitted by the additional public prosecutor that the service of notice upon the respondent number 2 is not necessary. Right? So stop. The appeal is admitted for hearing. Case record action again, LCR. The case records of so-and-so case number be called for. Release the case after 4 weeks. Heard Mr. I Alom, Learned Counsel for the applicant, appellant, and Mr. R. Kosik, Learned Additional Public Prosecutor for the opposite party number 1, State of Assam. Post up. The instant application is preferred by the applicant appellant seeking suspension of execution of the sentence passed against him and for his release on bail, full stop. The applicant appellant has preferred the accompanying criminal appeal against the judgment and order dated 28/5/2025 passed by the Court of Learned Special Judge POCSO Hemaji in special within bracket POCSO case number 06/2019 post of by the judgment and order dated so and so, the special court has convicted the applicant appellant for the offense under section 354 Indian Penal Code, and he has been sentenced to undergo rigorous imprisonment for 2 years and to pay a fine of rupees 20,000, in default of payment of fine, to suffer rigorous imprisonment for another 3 months. Post of para. It is submitted at the bar that since the applicant appellant has been acquitted of the charged under section 8, Protection of Children from Sexual Offences Act, service of notice upon the respondent number, opposite party number 2, that's informant, is not imperative, and the instant application can be considered without the presence of the respondent number, opposite party number -2 respondent, full stop. It is submitted that the applicant appellant, in order to prefer the accompanying criminal appeal, has been allowed to remain on previous bail by the Learned Special Court under section 3. Nowadays, what is BNSS?
430.
430,
Suspension
subsection 3. Full stop. Para. এই আগৰটো যে citation-টো যে কৈছিল fixed term এই যে কিবা গাঁওগাৰাম state of Gujarat. But having considered the period of sentence passed against the applicant appellant and so and so আগৰটো নিচিনাকৈ কৰি দিব 10,000.
Item 18.
My lord, this is a matter relating to bouncing of checks, my lord. It's come from the.
To pay a fine of 70,000.
We also went through.
This is what, an act?
Yes, my lord.
An act.
Yes, my
19 days, 119 days. We'll issue notice then. There is a private party. Basically, state is not involved. It is a private party.
But
State is formal here. Heard Miss D. Sinha, Learned Counsel, for the applicant on the instant interlocutory application
make a
is.
submission, my lord. In the statement 313 of the accused, petitioner now, she is saying that they have in her statements, she is denied of taking so many, and they have.
No, in everybody denies.
Denial.
Hardly
Yes, hardly.
0.0% or 0.1% admits.
After hearing the matter, but when I talked
No,
with them, it was
we
not so
cannot go into the,
simple.
Ms. Sinha, we cannot go into the merit
Yes.
unless
So there.
we condone the delay, right? Interlocutory application under section 5 of the Limitation Act 1963 is preferred, seeking condonation of delay of 119 days in filing the accompanying criminal revision petition against a judgment dated 25/11/2024 passed by the Court of Learned Sessions Judge Sibsagar in criminal appeal number so and so. Post of issue notice returnable in on returnable on so and so as Mr. Kosik appeared and accepted for opposite party number 1, formal notice dispensed with. The applicant shall take steps for service of notice upon the opposite party number 2 by registered post with AD as well as by usual process within 3 working days from today.
5/9, 5th September.
You want Dusty?
Yes, service.
Okay, I'll Dusty will give so that we can condone the delay.
Yes.
DPR.